Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the offices of Rajiv S. Khanna PC. This is a conference call we do for the community every other Thursday. Today is Thursday, February the 2nd, 2023. I have in front of me some posted questions, which is in our forums.immigration.com. There's a specific area right on the top of the forums where you can post questions for the next conference call. In the conference call questions that have been posted, I have marked some as frequently asked questions. I will first go over those questions, answer each one in turn, and ask you if you have any follow-up questions on what I have just discussed. At that point, there'll be no new questions, only follow-up questions. After doing the frequently asked marked questions, I'll do the other questions that remain that have been posted, and if time permits, I will answer new questions. Around midway into the conference, in about half an hour, I will lock the conference so that we don't get any new additions, and people who are already here, if there is time remaining, I can answer their questions. Welcome, all of you. Let's get started. My first frequently asked question was criteria for national interest waiver and national interest waiver for physical therapists. So first of all, understand what is national interest waiver, what is not national interest waiver. What it is not EB1. So national interest waiver is simply another category or another type of EB2 green card. That means even if you qualify for national interest waiver and you are India born or born in a country that is backlogged in green cards, it's not going to be immediate that you get your green card. India could be 8-10 years plus. On the other hand, if you were EB1, you could have a green card within a year or less, depending upon how the priority dates are moving. So national interest waiver is not EB1, number one. Number two, national interest waiver is really not that much based upon your qualifications as it is based upon the project or the contributions you might provide to the United States. So for example, let's say that you are a researcher doing research on autoimmune diseases. Okay. If you are researching for autoimmune diseases, we need to look at, number one, is your research going to, again, this can be a future job or a future project, is it going to help the national interest, not just local interest? So if you were working for a private company and you were helping them in their R&D, that might not be much use for the United States national interest. On the other hand, if your research is, for example, in the academia and it's open for the whole world, including USA, that might qualify you as a project that is in the national interest, number one. Number two, are you well positioned to carry out the project, which basically means you're qualified, and that's usually not a problem. Number three, and this is also important, is there interest in the United States in your project? So let's say you are an inventor who invented something, you're from South Korea, and you invented something, and now that something has generated interest in the United States companies, and you have a couple of letters of intent or letters of interest from companies in the United States, that would show that what you are going to do will have interest in the United States. So number one, it has to be a nationally important or nationally contributing project, what they call intrinsic merit. Number two, it is not something that you can do without some interest in the United States. So even a job is interest. So technically you don't need a job for NIW, but having a job is also interest, right? And the third thing is, are you qualified? And that's usually the last thing I worry about. There's a fourth element, which is highly technical. I don't need to go into it. So physical therapists don't have any special type of national interest waiver. So that information is incorrect. But physical therapists do qualify for something called Schedule A, where you can directly file for your green card without having to go through labor certification. Both nurses as well as physical therapists qualify for that. But that is not a national interest waiver. That's equally as effective or ineffective, depending upon which country you're born. Okay. Now let's look at the questions that are asked. Wife is on H-4 EAD. She is a physical therapist. Recently, I learned that physical therapists come under NIW. I already discussed that. Can her employer file for green card while she's on H-4 EAD? Absolutely. When somebody is on H-4 EAD, anyone, their green card can be filed, of course. If she's eligible for NIW, I doubt it. Okay. I've heard some recent updates regarding premium processing. I don't remember exactly what date under what terms they are starting premium processing for NIW, but if you Google it, you should be able to figure that out. Can she use my priority date to file an adjustment of status? No, she cannot. So that's one thing husband and wife cannot transfer to each other, their priority date. Okay, so that answers the questions. If anyone has any follow-up question, no new questions, any follow-up questions on what I discussed, press *5 on your phone, please. Press *5 if you have a follow-up question. Okay, there is one coming from, let's see, area code 347. And that is New York. Okay. New York, go ahead. I can hear you.
Hey, Rajiv, this is Ravi.
Yes,
I
sir.
posted this question.
Okay.
So one additional thing I would like to understand here is, as you mentioned, like this is a Schedule A job. And there are some differences in Schedule A job and they define regarding PWD or PERM. What I would like to understand, like, does she, if her employer files for a green card, does PWD and PERM both has to be done, or just
No.
PWD and not the PERM?
No, PERM is not required. And I don't remember exactly what we do for Schedule A jobs in terms of prevailing wage determination. I don't even remember if we do it or not. As far as I recall, we do not. And, don't quote me on this. I think what we do is we prepare the Form 9089. That's a part of the preparation. But we don't apply for prevailing wages determination. We directly file it with the I-140. That's what I remember. But other people in my team take care of all those things. So that's the way it typically works. I don't think you need a PWD. I could be wrong. Okay. But you definitely do not need a PERM because that's the idea. Schedule A are exempt from filing PERM. Okay.
Yeah, so PERM I was a little bit aware, but I'm not sure about the PWD because as of now, PWD also taking like 6-8 months kind of
Yeah,
thing.
I don't think you need a
PERM,
PWD.
So that, okay. Is there anywhere I can find this information online or like?
Yeah, it should be available on the U.S. Department of Labor's website. One second. Let me see if I can find it for you.
Okay.
I don't have my notes in front of me. Unfortunately, I don't have anything directly from the U.S. Department of Labor. I just did a quick search. I haven't spent any time on this. Our team would know all that.
Oh.
So if you look at the USCIS Policy Manual, Chapter 7, it talks about these are predetermined cases. U.S. employer submits an uncertified application. That's exactly what we do, which is 9089. It doesn't say clearly. Employer must be in occupations. I'm pretty sure we don't because we do so many cases for nurses. I don't remember ever looking at any PWDs. Okay. So if you want, if you're not able to, go ahead.
So basically, if PWD and perm is not required. You're saying like PWD will be prepared, but as a form, just as a form, and this. So
Not,
everything
no,
goes
no, no, no,
together
no,
like
no, no,
PWD,
no,
perm,
no,
or
no, no,
140.
no, no. That's not what I said. PWD is not prepared at all. What is prepared is the 9089, the perm form.
Okay.
Okay.
989. Okay.
Yep.
And then along with that, we can file 140.
140. That's what is done, to the best of my remembrance. Okay. I got to move on. You have another question?
Okay. Thank you.
All right. Good luck.
Thank you.
You're welcome.
No, I think that's all. Thank you. Thank you very much.
You're welcome. Okay, let's go on to the next question. Frequently asked question. Multiple companies applying for H-1B cap registration, H-1B lottery. I've talked about this many times. Almost every call we talk about this. So when the companies are completely unrelated, there is no interlocking project, end client, similarity of stockholders, management, when there is no connection at all between two companies and they are not colluding to help somebody get H-1B, increase their chances of getting H-1B lottery selection, multiple companies can file. And oddly, for bigger companies, even different units within the same company, if they have genuine need, could file and not have a problem. Okay. So first question, can multiple companies file for H-1B? I answered that. Is there a possibility that the employers might get to know about this? I don't see how. Should my name in the passport and birth certificate match exactly? Well, I don't know how to answer that. You have an abbreviation in your last name. That's normally not an issue. At some stage in your immigration journey, you should try to make all these names consistent, just to prevent any delay issues or any questions about your identity. Okay, so that's pretty much it. Star 5. If you have a follow-up question on this, press star 5. Okay. Let's go on to the next frequently asked question. Can H-4 visa, no EAD holders take an unpaid internship? And the answer is yes, but here's the problem. This I have discussed many times. It's on my LinkedIn page as well. I think it's also on my blogs on immigration.com, that an employee could definitely take an unpaid internship even though they are on H-4 or even any other non-work visa. But for-profit employers may not be able to legally offer you an unpaid internship. There is something called Fair Labor Standards Act, and there are some rules about how for-profit employers can give internships. But that's the employer's problem, not the employee's problem. So can they take it? Sure. For example, can you do an externship? Sure. I don't see any problem for you. The employer should watch out for themselves. Star 5. If you have a follow-up question on this, press star 5. Okay, let's go on to the next frequently asked question. One question I deleted. There were so many. That was such a lengthy fact pattern. There's no way I can do that in a community conference call. Can H-4 EAD start a business in any state? Can a relative's company file H-1B? The answer to both these questions is yes. Let me start with the relatives company question. A relative's company can very well do an H-1B for you, but they might have trouble getting you a perm-based green card. Even there we have been successful, most firms have been, if certain procedures are followed, but it's complicated. It can be done, but H-1B is not complicated. That's absolutely straightforward. Okay, star 5. If you have a follow-up question, star 5. All right. Let's see. Are there any other frequently asked questions? Yeah, here's one. H-4 visa dependent children change of status to F-1 before 21. Yeah, this happens all the time. She'll turn 21 in July 2024. By what date age she needs to change her status? Well, she needs to file for a change of status before she turns 21. Once on F1 status, are there a minimum number of months, semesters she has to complete before being eligible for a CPT or OPT? I believe it is 2 full semesters, 1 academic year. So double check that with the DSO, but I believe that's how it works. Now, I remember there was an exemption somewhere that if you're already studying, then all we really need is for you to be on F1 when you apply for your OPT. You don't have to have full academic year. I don't remember the details of that exemption. So that's why I said double check with the DSO. Okay. Star 5 if you have a follow-up question. Star 5. Okay, let's see. This question is from California. Yes, California. Go ahead, please.
Hi. Thanks for taking my call.
Sure.
So my question is, she is very likely she'll be finishing her degree before she is 21.
Mm-hmm.
So that means she has to apply now, because once what happens after she finishes degree before 21, and then if she applies for F1 there, then she can move it to OPT, right?
Yeah,
What if she doesn't
can
move it to F1?
yeah, double check that. I remember looking at both issues. One was that you have to have full academic year before you become eligible for OPT. The other one was, as long as you've been going to school full time, even if you convert to F1 at the last moment, will get you the OPT. I don't remember exactly what the details are, but there's some complication there. Double check with the DSO. This I know for sure, that if you have 1 year of 1 academic year, you're entitled to F1 OPT. But can you do it even without that 1 year? I don't remember. Okay.
So we need to check with the DSO. Of
With the DSO,
university,
yes,
right?
they will know.
Okay.
All right.
Okay.
Good luck, sir.
Okay then. Thank you very much.
You're
You have
welcome.
great system.
You're welcome.
Thank
Bye-bye.
you, sir. Bye.
Okay. Let's go on to the next frequently asked question, if there is one. Oh, here is another one. This is filing H4 and H1 simultaneously. Status of F1 once H4 is approved. Well, once H4 is approved, F1 is gone. Most efficient, if it's change of status, most efficient way to get EAD F1 or H4 depends upon your situation. Nowadays, from January 25th, if your husband is filing or your wife is filing H1 premium processing, you can piggyback your H4 and EAD, and that will also get premium processed. I would say that's pretty darn efficient. Okay. So the situation is you're currently on F1 OPT STEM, good till June of this year. Company is filing H1B this March. Should I be filing for H4 visa simultaneously? Well, see, the thing is, from 15th June, if you get selected in the lottery, you have, well, you'll know in March end, you will know whether you've been selected. If you've been selected in the lottery, you will get gap extension. So you'll be good to work till October 1st anyway. Okay. If you don't get selected in the lottery, then obviously you have to go to H4. You have plenty of time to figure that out. How long does it take for H4 visa, H4 EAD? That's public domain information. A few months. If I file for H4 in February, would I lose F1 as soon as my H4 visa is approved? No, visa, change of status. Yeah, as soon as the change of status is approved, you lose your F1. Is there any new policy where I can get H4 EAD sooner? I don't think they have, other than the premiuming of the entire bundle when you file with your spouse for premium processing. There is no other way, that, not yet at least, as of February 2023. Should I wait for H1B? I already answered that question. What is the best scenario to switch from F1 OPT EAD to H4 EAD without minimum employment gap? Yeah, it looks to me premiuming through your husband would be great if that works for you. Okay. Star 5, if you have a follow-up question on this, press star 5. This was from Aslisha. Okay. All right, let's go on to our routine questions. Starting from question number 3. Wait, I already covered this. 2, 3 I covered. Question number 4. US citizen child age 21 applying for parents' green card. Yes, they can. I've discussed this in detail in the last conference call also, and that should be reported in our frequently asked questions on immigration.com. And the financial support and all I have discussed, you can always get a co-sponsor. You might even be able to use your own assets for financial support. So I've discussed that in the last conference call. Star 5, if you have a follow-up question. Star 5. Okay. Let's go on to the next question. A role eliminated by the previous employer after approval of green card, but new employer filed supplement J. Will this be an issue for moral character for N400? I'm a green card holder under EB1C, eligible for naturalization in the next 2 years. My role was eliminated in layoffs by my employer who sponsored the green card. I joined another employer who filed I-485J soon after joining them. I received my green card, and after a few months, my I-485J by second employer too got approved. I rejoined my first employer after working for 11 and a half months after green card approved date with my second employer. I don't even know why you would join the first employer. You already had a supplement J filed for the second employer. Is this going to be a problem? I really don't see what the issue is, because you could have joined the old employer, and because of your supplement J continued with the new employer after 180 days of your 485 pendency as well, as long as the I-140 is approved. So I don't see any issue here. So I'm a little fuzzy about what your concern is. Press star 5 if you have a question on this. Press star 5. Okay, since you're not here, I'm not sure what your concern is. I'll go on to the next question. This one is question number 6. Benefits of working on F-1 OPT status and change of status. On F-1 visa for all the period, 485 was filed in June of last year, ended F-1 in September of last year. 180 days are over. I have my EAD. I can change my jobs. Although I have not been working since last year, as my OPT ended and went back to school, my company wants me back. I live in another state. I was not on H-1, and I've not been working for more than 1 year. Can I change my job? And the answer is, well, yeah. You don't actually have to be employed on the payroll of the company who sponsored you for green card, as long as you meet the AC-21 requirements. I-140 approved, 485 pending, 180 days. Even from a future employer, without joining the future employer, you can change your employer. Okay. Star 5 if you have a follow-up question. Okay. I have to appear for the interview shortly. I have to show my new job offer, or can I show even the employment verification letter from the other company? Okay, let's see. Yeah, you'll have to file supplement J as in John. Double check that with your lawyers. That has to be filed in all probability. But yeah, you can change jobs under AC-21 without ever joining the future employer. Star 5 if you have a follow-up question for this. Star 5. Okay. Let's go on to the next question. What happens if the Indian passport expires before filing US citizenship? As far as I know, nothing happens. As I recall, mine was expired too. You can double check with the USCIS customer service. They'll usually put you to an adjudications officer for a question like this, but I don't believe it's a problem. I can't think of why it should be a problem. Yeah. As long as you have a valid green card. Now, technically, with the valid green card, you must have a passport. But if you're applying for naturalization, I think you should be fine. I would check with the USCIS if I were you. It's probably a good idea. Okay. Star 5, if you have a follow-up question on this, press star 5. Okay, let's go on to the next question. This is question number 9. Same or similar occupation after getting AOS EAD or green card. Software engineer to project manager. And the answer is, this is now quite clear. You can have vertical movement or even lateral movement in a job as long as the jobs are same or similar. So for example, let's say that your green card was going on as a software developer, and the next job you get is in software, but it's in as a software project manager. I think you would qualify because it's a vertical movement. How about a CTO? I think you would still qualify. So there's no limit to the vertical promotions as long as the job that you will be doing requires similar qualifications. Okay. So same or similar, that's a very good example. If the job requires same or similar degrees or qualifications, you would qualify. Star 5, if there's a follow-up question. Okay. Then we come to Dhananjay Singh. Cross-chargeability rules. I'm an H-1B holder born in India. Perm is done. Okay, my current girlfriend was born in South Africa, currently in H-1B. We both live in Seattle. If I get married to my girlfriend, would we be able to file for adjustment of status via cross-chargeability? Definitely. Even though your perm was filed in New York City. Well, I do not know. See, that's a different question. Now, there are two different questions here. One is, if I get married to somebody born in South Africa, am I cross-chargeable? Yes. If I move from a location from which my perm was filed, am I eligible? That's a totally different question. That's something I would have to look at your perm for. You should talk to your own lawyers. They'll be able to tell you, or you can set up a consultation for us. Cross-chargeability is not a problem. Star 5, if you have a follow-up question on this, press star 5. Okay. Oh, there is a question. One second. Let me roll up to that again. So this one is anonymous and blocked, so I don't know who you are. Hi, go ahead. How can I help you?
Hi, Rajiv. My name is Kumar. I'm trying to similar situation. I recently applied for I-140 and I-485 concurrent filing, but this was due to my I-140 was revoked earlier. So I recently got an RFE on the refiled I-140 and I-485. The question is, my previous employer moved from one location to a city next to where my perm was actually approved. So the RFE is they want to USCIS is asking to establish a what do you call that metro.
Yeah, is it how much is the sir? How much is the distance between where the address used to be and the address is now?
12 miles.
How much?
It's just next town, which is like 10 to 12 miles.
Oh yeah, that should not be a problem. That's simple enough. Up to 50 miles, actually normal commuting distance, which is considered to be 50 miles, should not be an issue. Okay.
Okay.
All right.
How it can be established actually?
Or easy. Just do a Google. What do you call it? Google travel. When you do a map, destination X to destination Y.
Commuting distance.
Yeah, that tells you. No, when you want to go from location X to location Y, you say starting address, destination, and Google tells you how many miles it is.
Okay. So that is good enough for establishing for the RFE.
Well, I don't see what else you can do. I mean, that's very good evidence in my mind. Okay.
Sure. Thank you, Rajiv.
You're welcome. Good luck. Okay, let's go on to the next question. We did this already. Checking H-1B visa status expiration. Well, these are two different questions. While employed with my long-time employer on H-1B, I got the adjustment of status EAD card as well. However, I continued to get H-1B renewed. In July of last year, I had an H-1B visa stamp and passport expiring in September. Okay, a new H-1B approval notice expiring in March, and AOS EAD all are received. When the company asked for work authorization for the I-9 form, I gave my EOD, I guess that must be EAD card. Does that mean my H-1B status was paused or voided? Well, if you did it by mistake, they can go back and correct it. USCIS is usually not, they have nothing to do with your I-9. Okay. So it doesn't look to me like you would have automatically lost your H-1B if you did it in error. So for what that's worth, you can have your HR people go back and redo your I-9. Okay. Star 5, if you have a follow-up question on this, star 5. So when I say redo, they can do it as an error correction. You can't backdate an I-9. So just do as an error correction. I think that would work. Why not? Okay, there's no question on this. Now the question is laid off on H-1B, defining out of status and unlawful presence. Okay. So actually this should be a frequently asked question. Oh well. So what happens is, let's look at 3 dates that are important for you to understand. Date number 1, the day your 60-day grace period begins. Date number 2, when your I-94 expires. Date number 3, when we got the I-94, that's the H-1B. We got the date you quit working. The date of your last pay stub, or the date your last pay stub covers. Okay. I'm about to, let me just lock the conference because there are new people logging in. I want to make sure I cover everybody who's here if I can. So let me lock the conference.
The conference is now locked.
Okay. So first of all, what date the 60-day period, grace period begins? If you want to look at conservatively, I would say it is the date you actually stop working, the day after that. If you want to be very aggressive about it, you can say, as long as my pay period is covered by my paycheck, my 60-day period doesn't begin. Okay, I think that is also correct. So once we are past that 60-day issue, now the question is, do I have 60 days or less? So that depends upon your I-94. If your I-94 is expiring in 45 days, you don't have 60 days, you have 45 days. So I-94 time or 60 days, whichever is lesser. That's what you've got. When does unlawful presence begin? Unlawful presence will begin when your H-1B is revoked by the employer or when your I-94 expires, whichever is earlier. That's unlawful presence. Okay. So the question here is, latest H-1B visa stamp and passport expired September 2022. We don't really care about the visa stamp. The I-94 arrival departure record shares admit until September 2022. I-140 approval with a priority date of 2014. I-485 based on employment pending more than 180 days. I've got my AOS EAD AP in hand, expiration this year, 2023 August, and I also have a new H-1B. When will they start accruing out of status? When they stop working, unlawful presence, when their I-94 expires, or when their H-1B is revoked. How can this be mitigated? And that's a very long discussion. B1, B2 is one option. F1 is another option. H4, if you qualify, if your wife is on H1 or husband is on H1, that would be another option. There are too many variables for me to give a generic answer to that. But suffice it to say that your unlawful presence begins on the date your I-94 expires or the date your H-1B is revoked by your employer. Okay. *5, if you have a follow-up question on this, press *5. Okay. We did this already. Okay, so all the posted questions are finished. Anybody who has any question, please press *5 on your telephone. Anyone who has any question, press *5. I have 1 so far, 2 so far, 3 so far. Okay, anybody else has a question, guys? Only 3. Okay. I'm going to go in the order that you logged in. First one is 4 questions. First one is New York. New York, how can I help you? Go ahead, please.
Yeah, hi. Thank you for taking the call.
Mm-hmm.
So, Rajiv, my EB2 got approved in 2012.
Okay.
Then in 2020, my company filed 485 along with EB3 downgrade.
Okay.
After 180 days, maybe 7-8 months later, I changed my employer. My new employer filed I-485J, and in that 485J, he put the EB2 approved as the application and the AC21 possibility, everything. Now, 1 year later after that, which is like in December of last year, my previous employer received an RFE on the I-140, which is the downgrade.
Okay.
Now, since I have moved to a new employer, they are not going to respond to it. So my question is, what happens in the case they don't respond to that I-140 RFE?
Okay. And that I-140 RFE is for the downgrade, correct?
Yes.
Okay. And you never filed an I-140 for EB2, correct?
With the new employer?
At all. You've never had EB2 date become current for you.
No, I had just EB2 approved in 2012.
Yeah, but you downgraded to EB3. Okay. So if they don't respond, I think the EB2 would still survive. It depends upon what RFE they've gotten. If the RFE cuts to both cases, they'll throw out both cases. If the RFE cuts to only the EB3 case, they'll throw out the EB3 case, throw out the 485, but you'll keep your EB2 case if you want to go back to the old employer. Unless there is fraud, you should definitely be able to keep your priority date. So if I were in your situation, I would definitely start a new green card with the employer, the current employer.
Yeah, RFP is only related to asking financial information from the previous employer.
Yeah, that's a very major issue. Hang on.
Nothing more.
Hang on. That's a major issue. Because if there is a gap in their ability to support you, they will revoke both EB3 and EB2. However, they should not take away your priority date. Okay?
Even though my new employer has filed I-485J and the portability
That
rule
doesn't
says
mean a
that
thing.
after 180 days you can...
That doesn't mean that you're going to be able to survive a challenge to the ability to pay. Chances are, if there's a challenge to ability to pay, they'll throw out the EB3, they'll throw out the EB2 as well. If EB3 goes, so does the 485. So don't take any chances, start a new green card, okay? I got to move on to the next question. Good luck.
Okay, thank you.
All right, you're welcome.
Thank you.
Okay. You're welcome, sir. Yeah, this is an odd situation, but That's how it works. Let's see. Virginia has someone from Virginia. Go ahead, please, Virginia.
Yeah, this is Sailesh.
Yes, sir. Go ahead, Shailesh.
I have a couple of questions for the EB3.
Okay.
And like the requirement for the eligibility, is it current? If not, then how long it takes for approval, duration and procedure for approval? Can I stay in US while applying?
Wait. That's a lot of questions. Hang on. That's a lot of questions. I'm not sure I'll be able to answer them all here. And that's a very basic set of questions. So let me just tell you, EB3 requires a job that further requires either 2 years experience or a bachelor's degree. Not both. Even without a bachelor's degree, you could qualify for EB3. How long does it take? If you are born in India, 10 plus years. If you are born in a country other than India, it could be a lot quicker. And that includes your wife. Let's say you are born in India, but your wife is born in Nepal. You could take advantage of cross-chargeability, your wife's country of birth. Can you stay here while the green card is going on? No, you cannot. Okay. Anything else?
This is Sailesh's son, Anuj. The second question I had is, I read online that once your I-140 is approved, you can apply for the DS immigration visa. So meanwhile, your green card is still pending.
Okay. First of all, hang on. That's not how it works. I'll take one more minute and I'll explain it to you. I already gave you the answer, but now I'll explain it to you a little bit more. I won't explain any more than that. You can never file. There's no such thing as DS visa. DS 160 is a form you file to get a non-immigrant visa. What you need to do is to be able to file I-485 adjustment of status. Once you file AOS, you can stay in the United States and you will also get employment authorization. But you don't get employment authorization and you don't get to file the 485 until your dates become current, which means your date has moved far enough. And that's about 10 years. Okay? So there's no way you can stay in the United States just because your I-140 is approved. That doesn't mean a thing. Okay? What else?
Thank you.
Good. Well, good luck to you. Yeah, you're getting very bad information. I would say, I'm trying to think of where you can go for base. Yes, go to travel.state.gov. Travel.state.gov. That gives you the basic information about how to apply for a green card, etc. And that's a State Department website, travel.state.gov. Go to that website. Okay?
Okay. Thank you.
Good luck. All right. So then we have two more questions. Let's go to, I don't know, this is an unknown caller, so I really don't know. Hi. I can hear you. Yes, I can hear you.
Hello.
Yes, I can hear you, ma'am. Go ahead.
Yeah.
Hello. In my green card, middle name, 2 letters are missing.
Okay.
On my passport, it is my full middle name, full name.
Okay.
Can I go to India and come back without any issue?
Can you tell me how? What is the full name and what letters are missing? Just the middle name.
Natwar Lal. Middle name Natwar Lal. NATVARLAL. AL is missing.
I don't think that's a big deal. I don't think that's a big deal. You should be able to go to India and come back. I don't see any issue with that. Okay?
Okay. Thank you very much.
You're welcome. Good luck. And this is actually a database problem because when you are defining fields, you usually give a character limit because otherwise it takes too much space on your hard drive. You have to define how many characters. So Natwar Lal is NATVARLAL. That's 9 characters. They probably don't have room for that. That's why it's skipped. And that's a known issue.
Yeah.
Not a big deal. Okay?
Okay. Thank you very much.
You're welcome. Good luck. Okay. So the last question for today is from California. Yeah, California, go ahead, please.
Hi, sir. So my fiance's visa is expiring in the month of September.
Okay.
So we are planning of traveling to India in the month of June.
Okay.
So I'm not sure whether it's safe to travel during this time.
All right, hold on. What is your visa status? Are you a U.S. Immigrant or citizen?
No, I'm on my H-1B. So
You're
I'm
on
done with
H-1B.
my stamping recently.
Okay. Hang on. What is your fiance's visa status? What kind of visa does he have?
Even he is on H-1B, but he didn't travel to India for his visa stamping. So this will be his first time.
Okay. And you guys are planning to travel in September, you said?
No, in the month of June. And September is his visa expiry.
Okay. So normally, and I'm assuming that, and he has to get his visa stamp still, right?
Yes.
Okay. So what you can do is, this is what I would do: talk with your fiance's lawyers. But I think what he can do is, remember, you can ask for an H-1B extension up to 6 months ahead. So you can apply for an H-1B extension, let's see, in what, February or March, whatever the 180 days, 6 months is. Okay. So apply for an H-1B extension, get the extension. When you travel to India, you can present both for visa stamping. They might give you a visa stamping for the next 3 years, or they might give it to you only till September. In either case, you are safe coming back because you tried to get the visa for the whole period, but in any case, you have an extension for the whole period for the next 3 years. So I think the smart thing to do is get your H-1B extension before you leave. Okay?
Okay.
That's it.
And sir, like one more question, like while booking a slot in the DS-160, right now we don't have a new approval letter. So can we book the slot with the current approval letter and then change it later?
I think you
Like the
can.
document number?
I think you can. When you look at the State Department frequently asked questions, they actually tell you what you can and cannot do. So just Google DS-160 frequently asked questions. Okay?
Okay. Yeah.
Good luck.
Thank you so much.
You're welcome.
Thank you.
You're welcome. Okay, folks, there are no other questions today. Good to see you all, and I'll see you again in 2 weeks. Take care. Bye-bye.